welcome to the Regulatory 1515 podcast. My name is Adam Huckle, and I'm a partner in the regulatory and litigation teams here at Maples and Calder in the Cayman Islands. Joining me today is my fellow regulatory partner, Don Maguinhos, and one of our senior regulatory associates, Joe Ottaway. In this edition of the podcast, we will cover the latest developments in regulatory laws that have taken place in the Cayman Islands since the last 1515 episode, which aired in October of this year. That will include CIMA surveys, a new sanctions reporting requirement, the VASP regulatory forum, plus year-end reminders and a note on the FATF fifth round review. A bit of housekeeping before we begin. Please note that the contents of this podcast do not constitute legal advice and should be taken as a general update only. And also, please don't forget to subscribe and rate us on Apple Podcasts or Spotify. For timely regulatory updates across Cayman, the BVI, Luxembourg, Ireland and Jersey, visit our regulatory roundup blog at maples.com or click the link in this episode's description. And now over to you, Don, with updates on two recent CIMA circulars.
Thanks, Adam. Just a quick one. In October of this year, just a couple of days after our last 1515 podcast, CIMA published two industry notices in relation to two separate sectoral service surveys, each of which had a 31 October deadline. So they're all closed now, but it's worth mentioning that they occurred and talk about them at least at a high level. So the first survey was the Cayman Islands Virtual Asset Sector Survey, which was conducted in collaboration with the Office for Strategic Action on Illicit Finance as part of the Cayman Islands National Risk Assessment for 2025 and 2026. This survey sought to gather information from entities that are engaged in virtual asset related activities with the goal of improving the understanding of sector-specific operations, exposures, and associated risks. So I suspect that quite a number of our clients will have received this survey and hopefully completed the survey. So it will be interesting to see once CIMA publishes some of their findings coming out of the survey and some of the results. So we wait to see for that. The second survey was circulated by CIMA on behalf of the Ministry of Financial Services, which was actually done in collaboration with the International Monetary Fund. In that survey, CIMA sought feedback on factors that may make the Cayman Islands vulnerable to money laundering and terrorist financing through legal persons and legal arrangements, and the effectiveness of the measures that we currently have in place to mitigate these risks. This is all in the context of the upcoming National Risk Assessment for 2025 and 2026. So that's all I really wanted to say on these surveys, just the fact that they exist. They're closed now, so we wait to see some of the results. Adam, I think I'm throwing over to you to talk about the frozen asset reporting for 2025.
That's right. Thanks, Don. There is a new sanctions reporting obligation for 2025 in the Cayman Islands. This is the first year of what's called the Annual Frozen Asset Reporting Exercise, or FAR, and that requires a Cayman Islands person that holds funds or economic resources that are owned, held, or controlled by a designated person, i.e. an individual or entity sanctioned by the UK, to file a report with the Financial Reporting Authority, providing details of those frozen assets. Now, the deadline for doing so is quite tight. It is on Sunday, the 30th of November of this year. And as I said, this will be an annual reporting obligation on the same date each year. That reporting obligation will, by way of non-exhaustive examples, apply to Cayman Islands banks that hold frozen cash, or to Cayman Islands investment funds that hold underlying assets that are frozen, either because the designated person has a legal or equitable interest in those assets, or because the investment fund itself is deemed to be directly or indirectly owned by a designated person. Now, on the 6th of November of this year, the FRA published an explanatory note on the new FAR reporting regime, which is available on the FRA's website, as well as the Cayman-specific form, which is in Excel format. And the reason I say Cayman-specific form is this FAR reporting exercise is something that in the UK has been applicable to UK entities for several years. The reporting itself is relatively straightforward. The Excel includes details of the relevant frozen assets, including, importantly, confirmation of their value as at close of business on Tuesday, the 30th of September 2025. Other assets that you might hold that are frozen solely as a result of other jurisdictions' sanctions laws, so US OFAC, the EU, Canada, etc., do not form part of the FAR exercise, so don't need to be included. And the completed report can be filed with the FRA simply by emailing it to financialsanctions@gov.ky. If you would like our expertise, we have significant experience in advising on Cayman Islands sanctions law, so please do reach out if you would like to check if you're in scope of this FAR exercise or if we can be of any further assistance. Don, I'm hitting the ball back across the net to you on your next topic.
So another kind of an industry update. Just a few days ago, CIMA hosted a VASP regulatory forum for industry participants in person as well as virtually. So it's very interesting to see some of the topics being covered by CIMA. They're very helpful indeed. So I thought useful just to cover off what our listeners might find interesting coming out of that. There was a focus on the VASP registration application process itself, and CIMA was very helpful in identifying some of the recurring issues that they've noticed with applicants filing registration applications. So they highlighted that they've received some incomplete submissions. Some of the information they've received didn't clearly show group structures and beneficial owners, or didn't include some information that they necessarily need. So CIMA was very keen to make certain recommendations for applicants who are considering making an application. Engage early with CIMA. CIMA are very keen. In fact, it's a requirement of any registration application to engage with CIMA, discuss your plan, discuss your business. And it's only after CIMA given you the green light after that initial application or initial discussion with them that a broader application should be made. When you are making your application for registration, be as transparent as you possibly can with respect to your group structures and any other jurisdictions that entities in your structure are regulated in. Ensure that you have 3 directors lined up, so at least one being an independent, and having technical expertise in the area of virtual asset services that you are proposing to conduct yourself in. Ensure that your written policies and procedures are available, are in place, and are provided to CIMA as part of the application. CIMA do require them upfront as part of the application, so have them ready. And be prepared to answer any questions that CIMA have about the business itself. Obviously, Maples, we have great experience in helping clients with registration applications. So if that is on your mind, if you are needing assistance with respect to an application in the VASP context, feel free to reach out. Another aspect that CIMA did focus on is kind of what's coming up in the future. So they highlighted some of the forms and AML forms that they have updated, which enhance the questionnaires and the questions that they ask as part of the application process, specifically with respect to AML. And they did ask that entities that are registered under the VASP regime remind themselves of the ongoing obligations that apply to VASP, in particular, an obligation to notify CIMA or indeed get pre-approval from CIMA with respect to key officer appointments. So something to certainly be aware of. The other point, which I think is worth noting, is that CIMA did confirm that all VASPs, so all registered or licensed VASPs in the jurisdiction, will be inspected before the next the 5th round of FATF inspections. So very useful to know that anyone who is registered or licensed as a VASP will be subject to CIMA inspection. So certainly worth preparing for that, making sure that all your policies and procedures are up to date. All your documentation is spick and span. Again, Maples can assist with anything to do with that as well. So do feel free to reach out. So that's all I wanted to say about the VASP regulatory forum. It's staying with me now because I think we wanted to just provide our listeners with a very quick reminder as we approach the end of the year of all the various end-of-year obligations that come up in the regulatory space in the Cayman Islands. So I'm sure our listeners are well aware we're generally approaching economic substance return filing for those entities that do have or are relevant entities conducting a relevant activity that do have a 31 December financial year end. We will be approaching the time for filing your 2024 economic substance return. So be reminded of that. Don't forget, again, Maples can assist with filing that return or answering any questions you have with respect to it. We've now passed the general filing dates for FATCA and CRS, but a reminder about them nonetheless, because we have seen a heightened level of activity from the DITC in issuing breach notices and penalty notices to clients who have missed reporting obligations or missed compliance form filing obligations. So do keep that on the radar, put that in the calendar, make sure we don't miss it. Yeah, so a couple of things there just to be aware of as we approach the end of the year and to keep things in the diary for regulatory obligations going forward. As our last topic, I'm going to throw over to my colleague Joe to talk about all the various ways that we're preparing for the FATF fifth round review. Joe, over to you.
Thanks, Don. Yes, so our final update concerns the upcoming fifth round FATF mutual evaluation to be held at the end of 2027. So, as you may or may not be aware, the Cayman Islands is actively preparing for the mutual evaluation, which will focus on the effectiveness of the Cayman Islands' implementation of laws, regulations, and other measures relating to anti-money laundering, counterterrorism financing, counterproliferation financing, and sanctions. Now, CIMA has recently reactivated its blog, and it's encouraging all financial service providers to prepare for the upcoming mutual evaluation. In particular, CIMA is encouraging financial service providers to ensure that they have documented AML policies and procedures in place, and importantly, that they can demonstrate the effectiveness of those mechanisms. And this would generally be by way of an AML audit, which, of course, is a requirement under the AML regulations. CIMA is also encouraging board-level awareness of the upcoming FATF mutual evaluation process, as well as participation in as well as participation in national pre-evaluation initiatives and risk assessments. CIMA is also encouraging financial service providers to ensure that they have access to information, data, statistics, and case studies for up to 5 years before the on-site inspection, which can validate the effectiveness of their practices. CIMA is also requiring financial service providers to be able to evidence that an entity-wide risk assessment, including as regards proliferation financing risk, has been conducted. And as with all risk assessments, the risk assessment must remain up to date, consider current and evolving threats and sanctions requirements. Financial service providers should also ensure that there are adequate mechanisms in place for the collection, verification, and retention of accurate beneficial ownership information for legal persons and legal arrangements, which can be easily accessible when requested by CIMA or other authorities. And CIMA is also requiring financial service providers to make sure that all staff are aware of recent amendments to AML legislation. So, for example, as regards the recent downward consent changes, and that they are trained on any subsequent revised AML policies, procedures, and controls. And lastly, CIMA is encouraging financial service providers to take a proactive approach to the upcoming National Risk Assessment of money laundering, terrorism financing, and proliferation financing risks that will be conducted prior to the on-site assessment, as the findings of the National Risk Assessment will assist financial service providers in conducting their own entity-wide risk assessments. So if you have any questions regarding the practical steps that your business should be taking to prepare for the FATF's fifth round mutual evaluation, please do feel free to get in touch with us. We're very happy to help, and we have a range of tools that could be of assistance to you. Thank you.
So that concludes today's episode. Thank you to my colleagues Don and Joe for their very helpful contributions. And to our listeners, thank you for listening. If you've enjoyed the episode, please do rate us and subscribe. And we'll be back next month for another round of 1515. In the meantime, please make sure to visit our Regulatory Roundup blog for timely regulatory updates at maples.com, or click the link in this episode's description. Many thanks.